Well, hello, everybody. Hey, this is Bill O'Leary, and I'm coming to you live here in our weekly Thursday series. And so this is where every Thursday, although today is Friday, but I was busy yesterday, but every Thursday, sometime later in the afternoon, I dive into a topic that relates to estate planning, elder law, and probate, because that's what I do for a living. I'm the founder of Legacy Planning Law Group in Jacksonville, Florida, and we focus on things like estate planning, wills and trusts and estates and powers of attorney, elder law, estate planning for our seniors, and probate and trust administration. So if you're thirsting for knowledge, you're in the right place. So today what I want to talk about, an interesting topic, is so when should you name a trust as the beneficiary of an IRA? So first of all, a revocable living trust. It's a very common estate planning tool, and it's a great way to make sure that your estate ends up going to your loved ones smoothly, quickly, and easily without having to go through the mess that we call the probate court process here in Florida. It takes a long time, costs a lot of money, and revocable trusts are done all the time here in Florida because we're known as a probate state. And just as revocable trusts are very common, well, so are IRAs, also known as individual retirement accounts. A lot of people have them and they use them to save for retirement. But what if you have an IRA and let's say you don't spend all of it before you die? Well, you can make sure it passes on to your loved ones by simply filling out a beneficiary designation form. But what if instead of naming individual people as beneficiaries, you name a revocable trust? Is that possible? Well, yes, it is. Now, just a word of caution, you just want to make sure that if you do that, you do it the right way. You have to make sure that your revocable trust includes some very specific, important legal language to make sure that your trust is going to qualify as a beneficiary of your IRA under the tax law. And this is where you want to make sure you have the guidance of a good estate lawyer to draw up that trust for you with that special verbiage, those sort of bells and whistles. It's important you get it done right. But then the question is, okay, well, I know I need to do it right, to do the trust right, but under what situation and circumstances would it be a good idea to name a trust as the beneficiary of your IRA? Well, here are some good reasons to do it. Number one, divorce concerns. Now, nothing is so much that you as the account holder would get a divorce, but I'm thinking more of the beneficiary you have in mind. Say your child would end up getting a divorce after they inherit the IRA, and then that inherited IRA ends up going to your child's ex-spouse. While most people love their children and their grandchildren, they may not feel quite as warmly towards the people their offspring marry. And so there may be concerns about the money ending up in the wrong hands if their kids' marriages go south and there's a divorce. A trust, naming a trust as an IRA beneficiary, can alleviate these concerns. So to prevent that inherited IRA, inherited, let's say, by the kids, from being taken by the child's ex-spouse, naming a trust is a great idea. So that's the first sort of scenario or circumstance where it would make a whole lot of sense to name a trust as the beneficiary of your IRA. Second, creditor concerns, and I'm focusing on the creditor concerns that your inherited beneficiary, again, think child, would have. You see, inherited IRAs are not protected under many state laws, protected from a beneficiary's creditors once the beneficiary inherits them. A trust can help shield the IRA funds from your beneficiary's creditors. And not just a divorcing spouse, which I've already talked about, but also think your child gets into a car accident. It's their fault. Here comes the legal claim. If your beneficiary inherits the IRA directly, so their name appears directly on the beneficiary form, the account may be at risk of being taken in the lawsuit. Naming a trust instead can protect it, and you see, you would name the trust as the beneficiary of the IRA account, and then your kids will be beneficiaries of the trust. See how that works? Another circumstance is you have beneficiaries who are minor children. So when there are minor kids involved, naming a trust can be a great plan. You see, If you were to name a minor child directly on a beneficiary form, that is a recipe for disaster because a minor child cannot legally take the account. A guardianship legal case would have to be opened up, which requires legal action and expensive lawyer fees. Naming a trust solves this problem. Plus, most people don't want their minor child gaining control over that inherited IRA account when they turn age 18. So a trust can make sure that that inherited account not only will be managed for the child leading up to age 18, but can be continued to be managed beyond age 18, at least until the child gets older and more mature. And so especially, let's say with larger IRAs, when minors are involved, naming a trust as a beneficiary is a great solution when the beneficiaries are minors. Another situation, beneficiaries who are vulnerable. Look, there is no shortage of con artists and scammers that are just looking to take advantage of vulnerable or naive beneficiaries with large inheritances. To protect these individuals that may be vulnerable, naming a trust as the beneficiary of that IRA account can be really helpful for limiting access to that account and sort of warding off those that may have a malicious intent. Next circumstance, substance abuse issues. So look, no owner of an IRA account is going to want to see their life savings end up supporting a beneficiary's drug problem or gambling addiction or something like that. But by naming a trust as the beneficiary of that IRA account, instead of naming the individual that has the substance abuse issues, instead of naming them directly on the account, controls can be put in place to make sure this does not happen. And then the last situation I want to touch on. So if you have a beneficiary that has special needs, let's say is disabled. So for these special needs beneficiaries, a trust is really essential to manage money and to protect the government benefits that the disabled person may be getting. So once that disabled person inherits the funds, you don't want them thrown off, let's say Medicaid or some other government support help. A revocable trust can include special legal language to make sure that the beneficiary with special needs is going to be able to benefit from the money in the account over their entire lifetime. Want to learn more? We can help. We would invite you to have a discovery phone call with us. It's a free 15-minute phone call where we sort of start the conversation, tell us what's on your mind. Scheduling is very easy. You can either go to our website, Legacy Planning Law Group, click on the Book Your Free Call button, and you see it takes you to a booking calendar. Pick the day and time that works for you. Or if you happen to be seeing this video on YouTube, then appearing at the bottom of this video is a box that has popped up. Click on it, takes you to the same booking calendar. And again, that call is complimentary. If you've enjoyed this video, we would ask that you like it. And by the way, do subscribe to our YouTube channel. We're putting up more and more content all the time. So I hope you found this conversation today helpful as to when you should name a trust as the beneficiary of an IRA. As I said when I started this video, I'm going to be giving another talk next Thursday at about the same time, part of our Thursday series. So if you are thirsting for knowledge, we will quench your thirst. So Bill O'Leary signing off for now on behalf of everybody here, Team Legacy we call ourselves. Go make it a great day and a better world. Thanks for spending a few minutes with us today.